Welcome back to the China Law 101 video series. I'm your host, Edgar Choi from Law in a Minute. In today's video, we will talk about what Labour Arbitration is. The first question I would like to answer is, when do employees turn to Labour Arbitration? It comes to play in a variety of situations involving employment relationships such as the creation, alteration, or termination of contracts, as well as in disputes over wages, working hours, and obtaining release documents. Chinese law explicitly states that all labor disputes must first go to labor arbitration, also called the labor tribunal, before going to court. If you do not go through this process first, the court will simply not accept your case. So where do these disputes get resolved? It is important to note that there is a time limit for filing an arbitration claim, typically 1 year from when the employee leaves the company. Failing to meet this time will result in possibly losing the case. To file for arbitration, employees must submit an application along with their passports, work and residence permits, details about the employer, and a power of attorney. Proof of the employment relationship and any relevant evidence are also necessary. Employers, on the other hand, should provide their business license, legal representative ID, and evidence pertinent to the dispute. The application itself must detail the worker's personal and employment information, the specific arbitration request, and the grounds for it, including evidence like emails, contracts, WeChat conversations, bank statements, and the legal basis behind the claims. Please note that all claims and evidence submitted must be written or translated into Chinese. Evidence that is in any other language must be translated into Chinese, be it French, English, Arabic, or Spanish. WeChat has a user-friendly function that allows machine translation into Chinese, but for recordings, you will need to first transcribe it before translating it. Once an application is received, the arbitration committee has 5 days to either accept it and proceed, or issue a notice of non-acceptance explaining the reasons why. Should the application be rejected by reasons like having reached the retirement age, the applicants can take the matter to court within 15 days. Once accepted, the arbitration should be concluded within 45 days, with a possible extension for complex cases. However, the time frame can be recalculated if certain changes occur during the process. Moving on, let's talk about what happens in the courtroom. The trial process begins with the opening of the court session. The applicant sets the scene, presenting their personal identification while the respondent follows suit, offering up details of their place of residence and legal status. Following this opening ritual, the court must address an essential matter of fairness: the inquiry about recusal requests. This is a preemptive measure to ensure objectivity is maintained, allowing either party to call for the withdrawal of the arbitrator if impartiality is in question. The narrative then progresses as the applicant reads the Labour Arbitration application, laying out the story of the dispute. The respondent provides a counterpoint with their defense, setting up the conflict that would drive the remainder of the proceedings. As the trial moves into the arbitration hearing, the focus sharpens on the evidence and cross-examination phase. Here, precision is paramount. The employee's lawyer must present each piece of evidence succinctly, stating its name, source, and the purpose it serves in proving their claim. The respondent's cross-examination follows, after which the applicant may be tempted to offer further explanation. Both parties argue on the authenticity, legality, relevance, and purpose of proof of the evidence. The investigative phase of the hearing then commences, with the arbitrator probing into areas that remain obscured by the evidence presented. Questions are direct and require concise answers. Details such as employment dates, job descriptions, insurance payments, and the circumstances surrounding the termination of employment are clarified. With the courtroom stage set and the facts laid bare, the debate phase begins. Now, the applicant can freely address points previously left untouched. It's an opportunity to articulate their position fully, but they must avoid redundancy. Fresh arguments are welcome, while repetition is not. As the trial draws to a close, a final call is made for any last opinions or additional information. It's the concluding argument, the participants' ultimate chance to influence the outcome. The trial concludes with an inquiry about the possibility of mediation, an invitation for the parties to find resolution through compromise, rather than leaving the decision solely in the hands of the court. If during arbitration the parties come to an agreement, it is documented in a settlement agreement which is legally binding after being sealed by the committee. Should one side fail to comply, the other can request court enforcement. Thank you for watching today's video. Please feel free to share your thoughts in the comment section below. Stay tuned for our next episode where we'll explain whether mainland China verdicts are enforceable in Hong Kong.